All right, good afternoon again, everyone. Welcome to our assisted living webinar for today. I'm Matt Heffron. I'll be presenting today. I am our State Rapid Response Operations Manager. And during the presentation today, we'll be talking about what we mean by State Rapid Response and kind of what that covers. So for an opening introduction, I'll just let you know, I started my career in healthcare and emergency medical services. So my initial background was there and then went to law school. I'm a 2009 graduate of the Hamline School of Law, and I've worked for the state in different healthcare regulation capacities, essentially since then, starting at the Health Licensing Board, kind of moving back and forth between different legal and investigative positions, and then here at MDH for the last 7 or so years, working in what was the Office of Health Facility Complaints. And again, we'll expand later on kind of what that all looks like right now. Slide, please. So format for our webinar today, all participants are muted. If you would like to ask a question, please click on the chat bubble, open the chat and select everyone, type your chat in. The facilitators will ask the questions and I'll try to answer as many of them as we can today. Please don't send it directly to any individual. Use the to everyone that it should default to, and that'll best enable us to get through as many questions as we can during our time frame. And of course, remember this is a public open webinar, so please be respectful and also avoid any specific protected health information in your questions. But other than that, again, we'll try to answer them as many and as well as we can. Next, please. So what I'm going to cover here today is the process for complaint investigations. We'll look at it first, sort of the legal background of complaint investigations that are conducted by the Minnesota Department of Health. Then we'll look at the complaint process. We'll talk about your reporting obligations, and then just some tips derived from our experience doing complaint investigations of things that can help you avoid a maltreatment finding or a correction order as a result of a complaint investigation. Next, please. So I used the term earlier already, OHFC. That's the Office of Health Facility Complaints, and that's how you'll see a lot of this function described in Minnesota law. OHFC as it exists today is a result of 2 different state laws. One, in 1976, the office itself was created to review allegations that licensed healthcare facilities weren't complying with regulatory standards. You can find that statute in Minnesota Statutes 144A at 0.51 through 0.54. And that section outlines sort of the broad parameters that there will exist an office called Office of Health Facility Complaints, and here are some of its power and authorities. But then in 1981, the Minnesota legislature adopted the Vulnerable Adults Act, which you can find in Minnesota Statutes 626.557, and then the definitions relevant to it at 626.5572. And it made the Minnesota Department of Health the lead investigative agency for maltreatment in all the facilities that we license and regulate. Now, I will also note that the Reporting of Maltreatment of Minors Act also designates the Minnesota Department of Health as a lead investigative agency, and we carry out the department's obligations under the Maltreatment of Minors Act. However, since it's impossible for a minor to be a resident of an assisted living facility, I won't have anything particular on the slides related to that component of our work. However, for your broader awareness, if there is an allegation of a minor who is maltreated in a healthcare facility, we do that work as well. So for instance, at hospitals and at certain types of other residential treatment facilities and things, but it's just not relevant to assisted living. So the Vulnerable Adults Act and then the OHFC key regulation or the establishing statute are our key components for today. Next, please. So looking at that original OHFC enabling legislation of Minnesota Statute 144A.53, what it basically says is that our job is to investigate a complaint about an action or failure of a Minnesota licensed healthcare facility. And to do that, we have the authority to get access to documents held by the facilities, to subpoena either for those documents or for interviews of staff, to enter enter and inspect the facility at any time, and the issue corrections orders and fines. So that's sort of our baseline authority, and that's the kind of thing you should expect from us as far as entering and inspecting the facility, interviewing your staff, and looking at your documents. And we really think of that triad of activities as sort of the core of how you do an investigation. It's interviews, observations, and document review. Next, please. Now, when you add on the Minnesota Vulnerable Adults Act, there's a couple other nuances that come through. As a lead investigative agency under the Vulnerable Adults Act, we're responsible to receive reports of possible maltreatment. We then prioritize the report and make an initial disposition. Initial disposition is the term in the statute, but that really means our decision to investigate or not. And we have a dedicated triage unit, its own supervisor, and a couple of people with some varied healthcare and social work experience who look at all the complaints incoming and make that recommendation. Which ones do we investigate and which ones don't we? And we'll talk a little bit about that as we go along. The VAA also states that we have the right to enter facility and inspect facility records. So once again, that entering a facility at any time to inspect, to look at facility records. It also states that we can coordinate and exchange information with law enforcement. So if you have a more serious incident at your facility, such as sexual assault or theft from your residents, things like that, you can expect that we will be exchanging information with any law enforcement agencies that are also involved in the situation. And then finally, we're responsible for making what the statute calls a final disposition, which basically means we say, was maltreatment substantiated or not? And if it was substantiated, who's responsible for it? Next, please. Now, I've used the term lead investigative agency a couple of times, and it's worth noting that we're not the only lead investigative agency you might deal with. The lead investigative agencies under the Vulnerable Adults Act are primarily and first the county or tribe. So when we're talking about things like self-neglect, or when we're talking about maltreatment that occurs in the community outside of licensed facilities, that's the county adult protection responsibility, or if applicable, the tribe. So when we're looking at self-neglect, that is something that can occur within a facility as well. And it's possible in some situations that the county will be looking at that instead of us. You would also see this come up if an individual left against medical advice. And so they're no longer physically at your facility, and therefore the county is the one looking at whether this person is safe or not, whether they're neglecting themselves out in the community. They may be getting some information from you, but they're not investigating you per se. So county is lead investigative agency for that maltreatment that occurs outside of a licensed facility. Then, of course, on your opposite side of the slide, the lead investigative agency for facilities licensed by the Department of Human Services is the Department of Human Services Licensing Division. So that includes home and community-based services, adult foster care, child care providers, anything that holds any number of those DHS licenses. One of the things that can be confusing for some providers, of course, is that you may be dealing with DHS on reimbursement side. Of course, on the federal side, the Departments of Health and Human Services are one cabinet level agency. But here in Minnesota, the Minnesota Department of Health and Minnesota Department of Human Services are separate agencies with separate jurisdictions. So when it comes to who's your lead investigative agency for maltreatment, the question is, who issued the license that service was offered under? So if you are an assisted living facility, a hospital, a nursing home, a home care, a boarding care home, or a supervised living facility, that's us here at the Minnesota Department of Health. Even if the services the person is getting is paid for by DHS, if it's a service that's licensed by us, we're the lead investigative agency for maltreatment. On the other hand, some of you may be from companies that also operate DHS licensed facilities under CRS or similar types of rule sets. And in those cases, DHS licensing would have the maltreatment jurisdiction for those locations instead of us. Next, please. So what do I mean by maltreatment? The Minnesota statute defines maltreatment as just saying abuse, neglect, or financial exploitation of a vulnerable adult. So we could spend hours, and when we're training our own staff, we do spend nearly 2 entire days talking about what falls into abuse, neglect, and financial exploitation. But to just give a few minutes on that subject, the abuse definition in Minnesota statutes is very long and includes a couple of different angles or different ways of defining it. But it really boils down to 5 things that are abuse. One of them is physical abuse, and that is exactly what it sounds like. It's described as the hitting, slapping, kicking a vulnerable adult. So that's the type of thing that's covered by physical abuse. Pretty much what it sounds like. You are physically striking, grabbing, hurting the vulnerable adult. And if you have a staff member that does that, obviously that's going to be an abuse allegation. Then we have sexual abuse. So the components of the definition of abuse that have to do with this reference the definition of sexual contact in the criminal code, but it's a little bit broader than the crime of criminal sexual contact. It's specifically in that it says any sexual contact between a staff person and one of your residents is abuse, regardless of consent or not, unless it fits one very narrow exception. And that very narrow exception has to do with if they had a pre-existing consensual relationship before the caregiving situation arose, like they were husband and wife before they got admitted, one of them got admitted to the facility, or they were dating before the person started working here. So pre-existing consensual relationship and the person still has capacity to consent. So if you don't have that pre-existing relationship, any sexual contact between a staff person and a resident is abuse. So we will attempt to differentiate in our investigation whether it's one that's just technically abuse because it's a situation that's not supposed to happen, or whether it's truly non-consensual sexual contact. But it's important for you to know that either one is abuse. And so anytime that you have an allegation of sexual contact between a resident and a staff person, that's an abuse allegation and needs to be treated accordingly. The next one up we have, next category is something that we call verbal or sometimes emotional abuse. And this has to do with repeated abusive language towards the person or malicious language. So malicious language means the person is using words that are truly intended to cause harm and something pretty egregious. So something that would be language only has to fit into that malicious category to be abuse. So if you have a situation where a person, just kind of has a harsh tone, maybe uses some foul language, that's not necessarily abuse in and of itself. But there are certain things that I think we can all agree cross the line into that malicious language. Some of the examples were if that intent, like if they're intending to cause distress, like the person said, I'm going to go mess with this person, and then they go do it, that's more getting into the malicious character because they're intending to cause distress. And then, of course, when we're looking at things like racially charged statements or real other types of real discriminatory statements by staff towards resident where it's just so far outside the bounds of respectful communication that we would consider it malicious language, that would be another thing we would look at for abuse as well. The next component is what I refer to as abusive treatment. The statute contains a list that basically says treatment of a vulnerable adult that a reasonable person would find humiliating, harassing, threatening, or demeaning. And this is where a lot of what people tend to think of as emotional abuse really fits in more than in that specifically malicious language component. And here we're looking at not so much just the words that were spoken, but we need the whole pattern of behavior to understand whether it's abuse or not. And there's some specific court precedent that kind of sets the parameters of what fits within this or not. But it's just important to know that we look at it as a differentiation of, if you're just telling us about words that were spoken, then it needs to meet a certain threshold. But if you're talking about an overall course of conduct of how they treat the resident, then this language about humiliating, harassing, threatening, and demeaning is much more important. So that's where we can find some of the things like rough treatment combined with foul language might get you there. Setting up a humiliating circumstance for the resident, unfortunately. There's a lot of different possible scenarios that fit within it, but we're looking for that humiliating, harassing, or threatening type mostly to get us to abuse. Then the final category of abuse is what people tend to refer to as restraints. The main phrase the statute uses is actually unreasonable confinement. And so the fact that the statute uses the word unreasonable implies that there are situations where it's reasonable. And so we're not looking here at situations where a restraint has actually been ordered, someone who has prescribing authority. And we're not talking about emergency situations like the resident is actively swinging at someone and someone grabbed their arm. We know those situations occur. They may or may not be a violation, but we're not going to find abuse in those type of situations. For abuse, we're looking at something where there's no emergency and there's no order, but they still confined or restrained the person in some way. That's going to be abuse. Of course, the widest type of allegations that we handle are the neglect allegations, which is described as failure to provide reasonable or necessary care or services. And that's where there's, of course, that wider amount of nuance in what's reasonable and necessary. And there's a huge array of circumstances that could fall into that. But we're looking at knowing what the facility and your employees knew at the time. Did you provide what a reasonable healthcare provider would have provided to that person? And if you didn't, what was the outcome to the resident? So neglect allegations are the bulk of our work. In financial exploitation, we've got a couple of different versions of the definition of that in statute as well. The key ones that apply to our work are using, withholding, or disposing of a vulnerable adult's money or property without authority, or acquiring possession of the vulnerable adult's money or property through deception or undue influence. So you can see in that first one, it's just the mere fact that you used, withheld, or disposed of the vulnerable adult's property or money without the authority to do so is enough to get to financial exploitation. So typically our ones where we see this occur are things like the staff person who stole jewelry from the resident's room, or the staff person who took the resident's cash, or took the resident's checkbook and wrote out checks to themselves. Those are typically the ones that occur in that category. And then the second definition I mentioned, acquiring possession of the vulnerable adult's property through deception or undue influence. You can kind of imagine, I would think, some of the deception and undue influence things. So these are situations where the person, applies some type of pressure or makes implications to the person about what will, that'll impact their care if they don't borrow me this money. I won't be able to come help you anymore, or if you don't let me use your car. There's a lot of gray area in that one, but we're really looking for that deception or undue influence, and remembering that that person is dependent upon your staff to greater or lesser extents, we understand, but they are dependent in some way. And so that there's a lot of ways that a staff person can sort of cross that line into undue influence. In that sort of general idea of the exploitive transactions with residents. It's important to note at this point that we're looking for that undue influence or without authority type components to substantiate financial exploitation. However, it's also a violation of your licensing statute for your staff to borrow money from residents at all. So even if we end up not substantiating financial exploitation because, it's possible that the resident consented to it, or that we can't prove the undue influence or things like that, it may still be a violation, just not maltreatment. The final component that fits under financial exploitation is our whole world of drug diversion. And unfortunately, as I think many of you know, the opioid use epidemic across our state continues. There's with fatal overdoses occurring nearly every week. The volume of this, that's stuff diverted from healthcare facilities, fortunately is not high. However, it is a component of it. And one of the conclusions we've reached is that when a prescription medication is assigned to a particular resident, like their insurance or their money or their benefits program has paid for it and it's prescribed to them, even if you're centrally storing it, it's still really their property. So when a staff person then takes that for their own use or to sell or anything that's not the correct chain for that drug to be in, of getting from pharmacy to facility to residents correct prescribed use, anytime the residents or a staff person's taking it out of that chain for some other purpose is drug diversion, and it could well be financial exploitation because they are then using, withholding, or disposing of something that belongs to that vulnerable adult. So that's the kind of our world of things that we investigate as maltreatment. Next, please. All right, so all of these functions that I've described of our maltreatment investigations are primarily conducted within what the state operations function of Health Regulation Division here at the Department of Health. So right now in our Health Regulation Division, we have Daphne Pons as one of our executive managers. I think you've heard from her on some of the previous presentations like this. And she oversees three of us operations managers. One is the evaluation team that conducts the routine surveys, the scheduled work, if you will. And so that's your 3-year surveys for home care providers and for you guys in assisted living, the every 2-year surveys. We also have a manager that oversees our engineering staff that deals with the facility building and other physical plant type issues, as well as that section also includes our health occupations program and mortuary science team that regulate a number of different niche areas in the healthcare industry in the state. And then my team is the rapid response team. So we do all maltreatment investigations. So in state licensed facilities, that means both doing the compliance component and the maltreatment component of every complaint investigation. And then we also do a maltreatment component only in some other facility types. Our teams also are the ones who do initial surveys in the home care and assisted living world. So if you are a provisional licensee, you will see my teams doing your initial survey to take you from that provisional licensor onward. And then once you are licensed and you've, so to speak, passed that initial survey, then you go into that every 2-year cycle with the evaluations team. But that initial survey will be my teams. And then, as I said, we do all of the complaint investigation world work in the assisted living and home care provider world, and then maltreatment only investigations in other provider types. Next, please. Right there. So this really just summarizes, I guess, what I just said. What we do in state rapid response, the teams I supervise, are all the complaint investigations in state license only facilities. Typically, we're showing up doing both a combined compliance and a maltreatment investigation. So we're looking both, did you meet your licensing standards? And if not, are we issuing any correction orders for that? And then we're also doing that maltreatment component that I've just talked about. We're also doing the maltreatment component only in federally certified facilities. So if your company, for example, also has a nursing home, they would hear from us, but it's a 2-step process for nursing homes where the federal survey teams do the compliance component, and then we come later if there's also a maltreatment component and collect some additional information to substantiate or not that maltreatment. And then, as I mentioned, we also, in state rapid response, we do your initial surveys for home care and provisional assisted living. Next, please. So to look at our whole complaint process from start to finish in a more visual format, again, we get in thousands of complaints a year, and I'm using a very generic thousands because over the course of this year, we have had an increase in the volume of complaints that come in for state licensed only facilities. And because assisted living licensure has existed for less than a year and a half at this point, we don't know whether that trend has peaked or not. So I'm saying generically thousands because we'll see as this community develops how many thousands a year. But we get those thousands of complaints in a year through our intake. Those that are our jurisdiction then go on to our triage unit that I described earlier, where they review and assess the complaints. They select ones that will go on for investigation. Those that have a licensing order or a maltreatment finding go on to our enforcement staff for those letters to go on. And then again, if anybody is individually responsible for the maltreatment, that goes on to background studies for the potential disqualification process. And we'll expand on all of those for the next few minutes. Next, please. So intake of complaints and reports. I'm sure all of you are aware of the Minnesota Adult Abuse Reporting Center, or we tend to say MARC. Has 24-hour-a-day telephone reporting and web reporting. You should use this to report incidents at your own facilities unless you're required to use NHIR, which would only be our certified nursing homes. You should also always use the Minnesota Adult Abuse Reporting Center for reporting any issues that happens at another facility or for reporting self-neglect. And for reporting self-neglect, this should include, for your purposes, people who leave against medical advice. So if you know you have someone who requires certain services, like they're not safe if they don't have someone else managing their medications or helping them with their ADLs or things like that, and they leave, you should make a call to MARC and report that as self-neglect. And as we mentioned in our thing about lead investigative agencies, the county should pick that up and check on that person and make sure they're okay. As I mentioned, if you are a certified nursing home, you would also know about the NHIR system, and you would report incidents in your own facility from there. We also do, in addition to those two systems, get emails and letters into our office. I would tell you all that if you do have a concern, it is usually best that you go through the Minnesota Adult Abuse Reporting Center. So go ahead and use their web form or go and follow their number and make the report that way. Because if there is any maltreatment component to the incident, whether it happened at your facility, someone else's facility, wherever, if there's any maltreatment component of it, it needs to be reported at MARC. So if you send it all to us in an email and it needs to be investigated as potential maltreatment, we would end up having to make that MARC report ourselves, and we don't know if we'd be representing your concerns correctly off of your message. So I would encourage you, if there's any possibility that you're alleging neglect of a resident, whether you're reporting on yourself or whether you're reporting on someone else, please do consider using MARC for that. Next, please. Now, the Vulnerable Adult Act does require you to report when you have reason to believe a vulnerable adult has been or is being maltreated. It also requires you to report if you know a vulnerable adult has sustained a physical injury that's not reasonably explained. So the short answer of when you should make a MARC report on your own facility is if you have any reason to believe someone has been or is being maltreated, or the unexplained physical injury. You're required to report as soon as possible, and then the statute goes on to define immediately as within 24 hours. So the sooner you report, the better, but absolutely report within 24 hours. That 24-hour clock is what we will hold you to in terms of correction order. And it's important to note that we will hold you responsible for anything that any employee knew. So the key thing at this point is to understand that the point at which the facility knew, and therefore that the 24 hours started ticking, is the point that the first employee of the facility knew. So your internal processes for reporting a concern are very important to making sure you're compliant with this. And so every staff member should know that they can and should promptly elevate any concerns of maltreatment, because if that frontline direct care person knows about it and they don't tell it to the nurse for 3 days, the nurse could report it the minute she hears about it, but it doesn't matter. You're already late, because the 24 hours started ticking when that frontline staff knew about it. And so that's the key thing for avoiding a correction order on that front, is everyone needs to know to be able to elevate those issues. The majority of reporting violations we see, of course, are related to the issue of an incident that happens over the weekend and the direct care staff don't call someone, it doesn't get reported until Monday morning when the director of nursing or the administrator now knows about it. And while I hate to tell you that someone has to be available 24 hours a day, they do need to have that. You do need to have that ability to report to Mark at any point. So someone needs to be empowered and responsible for doing that on incidents that happen over the weekend. I do see someone ask the question of what about a person who's alone, experienced the fall and had the injury. Again, we would consider the facility knowing about the incident as being when the first staff member found out about it. So the clock in that case may not start ticking when the incident happened, but rather when the first staff member is aware of it. Next, please. So that's your reporting obligations. All of that comes into our intake unit, and then it moves on to our triage team. They're making the initial dispositions notifications, and they're also prioritizing complaints so that the most serious ones get looked at first. Even among those we are going to investigate, some of them are higher priority than others. And so that prioritization that they do is really important to the way we work. Obviously, we cannot investigate all concerns we receive. We receive complaints, again, thousands a year of all differing levels of severity. Some thoughts about how we triage. We do try to focus on incidents where harm has either occurred or is likely, and then we can prioritize other violations as the current situation requires. So for instance, during COVID spikes, we prioritized infection control complaints. So whereas in other times of our history, we may not have gone out on some basic infection control violations, or we may not have done so very rapidly. We did over, say, last winter, because it was an evolving issue that needed to be addressed more timely. Right now, one of those is also discharge, closure, and transfer violations, just because it's been a more pervasive issue. So those are ones that are prioritized now that may not always be. Again, just the prioritization varies a little bit as the situation in the industry evolves. But overall, we're focusing on, was someone harmed or is someone very likely to be harmed? During this triage process, you may be contacted by one of our triage staff for more information. Sometimes if you've self-reported an incident, we'll need to see the resident's service plan to know whether it's something we're concerned about or not. So that's something that happens throughout this process. Next, please. So when an incident is selected for investigation, this is what the investigation process largely looks like. We do most of our investigations in assisted living providers as on-site investigations. So one of my staff will show up at your facility and will typically introduce themselves, and often will want to immediately conduct some observations of the facility. So they will walk around your hallways, take a look at some different things. On-site observations are a key part of the investigative process, and so we like to get out quickly and start getting a feel for what's going on at the facility, and what kind of operation are you, and to really get some context for what we're going to be looking into. We're required to do interviews of the vulnerable adult if possible, any alleged perpetrator and family, and then of course any witnesses of the incidents. We will review documentation, so we'll request things from your facility. We'll also be requesting outside documentation if it's relevant. So if the resident went to the hospital afterwards for the incident, we may get hospital records. We may even get, say, the ambulance run report, things like that. And again, if you've had experience at a nursing home recently, or you go to one after this, you should know that for federally certified providers, this will be a two-step process where it may be one person doing the on-site activities, and there may be a different person from my teams doing some phone interviews after the fact to wrap up the maltreatment component, because for federally certified providers, that compliance component and maltreatment component are separated. But for you in the assisted living world, they'll be united, and it will typically be one person doing the entire complaint investigation. Next, please. So think some of the key things, what you should expect from us then. One of them is that we are never going to tell you who made the complaint. Now, I know in many cases you may be able to guess who made the complaint. We will not be able to confirm or deny that. I know I've been on many investigations where a person said, "Oh, I'm sure this is what Darlene said." Well, I can't respond to that statement at all, because the one thing we're required to always keep private is the identity of the complainant. So we can't confirm or deny who made the complaint or where the reported concerns came from. We will make observations of how you're providing care. We will typically scan in documents or ask you to send them to us. So we're really trying to move towards a paperless system where our staff are not carrying around reams of sensitive medical records. So we have portable scanners, and if you provide us paper records, oftentimes we will scan them in while we're there and then leave the copies with you. As long as we get a good scan of it, we only want to take it electronically and not have the liability of carrying paper with us. We will, in many cases, ask you to send records to us instead. So if it's compliant with your facility's security policies, ways for you to email and fax us information are available and highly appreciated. We will do phone interviews after we leave. Certainly, we want to talk to whomever we can that has relevant information while we're on site, but you should expect that we will call some people after it. We won't confirm or deny who we're calling or why. We may want to talk to some administration after the fact. We may want to talk to direct care staff after the fact. We'll almost certainly be talking to the family after. And what you should expect from us on all of that is that we will be professional and respectful. If ever that is not your experience with my staff, please make sure to let us know. What we expect in return is please provide documents in a timely manner. It is in all of us' best interest for us to not be on site too many hours. The sooner we get what we need, the sooner we can get on with our work and get an outcome to the people who deserve those answers, and the sooner you can get on with your day without us being in your hair. And also, of course, we expect you to allow us to talk to residents and staff. We want to do that in a way that doesn't interfere with the care you're still providing to everyone else. But we do need to be able to interview people if they're available on site, and please work with us on making that possible. Next, please. One thing that can occur during the course of an on-site visit is an immediate correction. If you're familiar with the federally certified world, there's that whole process related to an immediate jeopardy situation. For our audience today, I'll kind of skip over that. For state licensed providers, we can issue a correction order with a time period of correct of immediately. If you can correct adequately to remove the immediate likelihood of harm, we'll document that the immediacy is removed, even if the incident is still a violation. If you cannot make those immediate corrections, we'll make judgments of when or how to follow up based on that. And so this is just based on if our staff see something that appears to pose an immediate risk it's a violation and it's likely to cause some type of imminent harm to one of your residents, we'll do that immediate correction order. We will get it to you in writing as quickly as possible, but we'll also try to let you know like what it is we're concerned about so you can get started on that right away as well. And those can range from a couple of different things. Some of them are more technical violations, such as if you have staff working who do not have a background study completed, we do expect you to immediately start addressing that issue. If you do not have a licensed assisted living director on your staff, that will be treated as an immediate order because that's just not consistent with what you're licensed as. But others are more like what you, the immediate jeopardy situation where something is occurring which we believe poses an immediate risk, and we really need you to immediately take a look at it and mitigate that risk. Next, please. Aside from any immediate orders, though, the investigation outcomes are really two different things. Typically, again, we're there on a combined compliance and maltreatment investigation, so you'll usually receive two documents from us. The compliance component are correction orders issued under your licensing statute. This may include fines, depending on the scope and level of the violations. If you have violations that we're documenting, but they're low level, there won't be fines. Otherwise, the fines will be dictated by what the scope and level of the correction order is. And then the maltreatment report is a narrative report stating that maltreatment was substantiated, inconclusive, or not substantiated. And if it's substantiated, it'll say facility or individual responsibility, or in some cases, both. Next, please. Now, and that component of determining responsibility, I think, is one of the key things we wanted to talk about today. Is the Vulnerable Adult Act requires us to consider three factors in determining responsibility. One of those could be if the actions were following an erroneous order, prescription, or care plan. We understand that most of your staff are not healthcare professionals. They're what we consider unlicensed staff. You've trained them to do this job, but they're largely dependent on the training and instructions you provide them. So we don't want to hold them responsible for maltreatment if they're just following the instructions that they were given. So that's one of the first components of determining responsibility. And that really kind of goes into that second component, comparative responsibility between the facility and others, considering the adequacy of your policies, procedures, training, staffing levels, and supervision. So that's requiring us to look at the big picture. Comparative responsibility is a term with some legal history related to we're allocating responsibility between different people who are responsible for especially some type of failure, typically in our neglect components. And we're looking at, was this an individual who really sort of went rogue and didn't do their job, or did something they're not trained to do, or did something that was completely unexpected? That's going to tilt much more towards individual responsibility. Or is this someone who, whether or not they were really trying to do the best they could, but if was handicapped by a lack of processes, a lack of training, or by staffing levels that made it impossible for them to carry out their duties. So those are the kind of things we're trying to weigh in that comparative responsibility component. And then finally, whether the facility or individuals follow professional standards and exercise professional judgment. And that's going to fall mostly then on your licensed staff of your nurses and your LALD, and whether their actions were in accord with the professional standards of their profession. We, again, as I said it earlier, we understand that many of your staff are unlicensed staff who don't necessarily have a background education in this field. And so we don't want to hold them responsible for things that are outside of their education. The flip side of that is you do have a right to expect that your licensed staff, like your nurses, have a certain level of competence at baseline. And so if they fail to exercise professional judgment up to the level of their licensure, then that's more likely to be on them. Whereas we might not expect that same level of judgment from someone who doesn't have that education and training. Next, please. Once those documents come out, the enforcement cycle, again, For federally certified providers, that's all dictated by CMS, and there's fairly strict rules around that. For state license only providers like our assisted livings, you don't have any requirement to submit your plan of correction to us. Nursing homes do have to submit their plan of correction to us. You don't. You do need to document the actions you took to correct anything cited. We don't pre-approve your plan of correction, but we want to see it when we do a follow-up visit. We don't do follow-up visits on all types of violations, only on the higher level violations or as needed. But we'll do that follow-up visit to determine if you made corrections. There's sort of, and that's our main component of our enforcement cycle. You'll get your set of correction orders, you'll correct issues in it. We may or may not do a follow-up visit depending on the scope and level. If we do a follow-up visit, that also may not be an in-person visit. For example, if something that you could document correction of by documentation, we may contact you and just ask for that documentation and then be able to deem it corrected. So those are all possibilities. And again, all of that correction order process, you'll get a letter which will outline if there are any fines associated with those correction orders as well. If you are a provisional licensee, you're getting your initial survey. That letter will also include the decision on denying your license, granting it, or extending your provisional status with some type of conditions on your license. So that's one of the key things to look for. If you get a letter from us that says you're granted, then good news, you are in substantial compliance and you passed your survey. If you get a letter saying you're denied, then you will need to appeal that or shut down. And if you get one saying conditions, you need to make sure you're in touch with us about complying with those conditions. If you're not provisional, if you're one of our other licensees and you have a significant number of correction orders, we do have other enforcement actions we can use in those situations as well. The most common one is conditions placed on your license. You'll receive a letter from us in those situations outlining that due to these violations, you're required to do these additional things to correct. Typically, what that'll involve is us giving you a longer period of time in which to fix the violations, but requiring you to hire an outside consultant to help you through that process and make regular reports to us while you do it. You may also be barred from admitting new residents while you work on those corrections. And so those are kind of what you could expect to see in a conditional license. On more extreme cases, we could refuse to renew, suspend, or revoke your assisted living facility license. Those actions have been rare so far, and we would hope to keep it that way. But it just depends on what we continue to encounter in this out in the industry. Next, please. All right, so the other outcome from a substantiated maltreatment finding is the impact on individuals. If an individual is held responsible for maltreatment, if they're a licensed staff, like a nurse or the LALD, then maltreatment finding will be submitted to their licensing boards. Nursing assistants will have that finding placed on the nurse aid registry, which does impact their ability to be employed in some provider types. All unlicensed staff, including nursing assistants, can be disqualified from working in healthcare and human services for 7 years if the maltreatment is considered serious or recurring. So not absolutely every maltreatment finding against an individual will result in them being disqualified. You have to wait for the DHS Background Studies Unit to issue the new letter saying it, whether it is or not, but many of them are in that serious or recurring category and do result in that person being disqualified from working in health and human services. Next, please. So kind of to review again, this is the process we've talked about. We get the complaints in, we triage, we investigate. For your enforcement process, you'll get those 2 letters. One, no correction orders, or here are your correction orders. The other one, here's your maltreatment report. Someone was or wasn't found responsible for maltreatment. And then if an individual was found responsible for maltreatment, then there may be a final step of that disqualification letter. Next, please. So I'm going to go quickly through these next couple of slides, but these are sort of our top couple of tips for avoiding a maltreatment finding or a serious correction order during a complaint investigation. Number one, protect residents from sexual contact that they don't have the capacity to consent to. Another one, when residents have systemic issues, whether falls, behavioral things, altercations with other residents, please keep trying new interventions and document all of those attempts. We need that trail of things that you've attempted to do to address that problem. If you have that trail of we tried this, it happened again, but we tried this, it's unlikely to be a neglect finding. Number three, have a low threshold for conducting a change of condition assessment. Number four, follow best practices regarding drug diversion. And then finally, please give written notice for anything you do that resembles an emergency relocation, transfer, or termination of a resident. I'll expand on each of those, on a couple of those for just a second. Next, please. So for the sexual contact one, obviously sexual abuse in long-term care facilities does happen. If you have an allegation of staff having sexual contact with a resident, get law enforcement involved, make your mark report, get the alleged perpetrator out of the building, encourage a sexual assault examined. Please don't wash clothing or bedding until after law enforcement is involved. You don't want to be in a situation where we're destroying potential evidence of it. So if it's an allegation of staff having sexual contact with the resident, please treat it very seriously. We know there are residents who have memory issues and they're really talking about an unfortunate incident that happened to them decades ago. We have residents with delusions, but please don't write off anyone's report of it. Look into it, investigate it, and take them all seriously. If you do have residents that are having sexual contact with each other, document your assessment of their capacity to consent. If you don't think they can consent to it, you should protect them from it. Next, please. So drug diversion, theft of controlled substances from healthcare facilities is a persistent problem. We talked about that briefly. One of them, I would encourage you to check out the prevention of controlled substance diversion in long-term care toolkit that MDH was involved in creating a couple of years ago. And you should consider it your responsibility to proactively monitor for that, whether that's in controlled substance counts, regular audits of what's dispensed, all of those type of things need to be part of your plan. You need to be looking for this, not just when you start suspecting something, but as an ongoing practice. Next, please. And then discharge notices, please give written notices for anything that looks like a notice of termination of services or housing. Use the content that's in the statute